justice, which are, if not unknown, certainly overlooked, and then touch on two looming dangers which are also the public is unaware of, and which I think UKIP needs to campaign on urgently. The first fact is the centrality of criminal justice in any state organization. It's not it looks like a government department like many others, but in fact, criminal justice means police and prisons. It is the means whereby the state takes the power to arrest people and lock them up. Physical coercion of the state over the citizens. This is why the EU wants to control our criminal justice. The second point is that the difference between our system of criminal justice and the system of systems, but they are part of the family, of criminal justice used on the continent, go back centuries. Next year will be the 800th anniversary of Magna Carta. Magna Carta was the first attempt in the history in human history, I think, whereby the people of a country tried to, and succeeded in putting limitations on the power of the state, the king as it then was, the central government. And one of the crucial freedoms safeguarded by Magna Carta, which is still valid today, is trial by jury, which means that the king, the state, the central power, cannot punish a citizen except by the permission of 12 of his peers, people, ordinary people. So we have a two-legged democracy where ordinary citizens not only elect the lawmakers, but they also decide when, serving on a jury, they decide when the laws shall be applied to a citizen in the most violent way, depriving that citizen of his rights and putting him in prison. When we were having Magna Carta in 1215, on the continent they were getting the Inquisition. The Pope, Innocent III, at that time, was setting up the apparatus for the Holy Inquisition. And the essential feature of this was to take the function of investigator, prosecutor, and judge and roll them up into one and put them in the same pair of hands, the inquisitor. When he heard that in Britain, in England, we had obtained Magna Carta, he was furious, and he wrote very rude letters to the English bishops and abbots who had signed it. Since then, Napoleon, there was the Inquisition ravaged continental countries for centuries, and it was used as an instrument to stamp out opposition by witchcraft and heresy and scientific thought. Galileo springs to mind. Well, in the 18th century there was the French Revolution, and it looked as possibly there was going to be a change of system. But then Napoleon took over, and he, instead of overturning the inquisitorial system, he established it, he adopted it and adapted it and put it to the service of the state instead of the service of the church. And today, to this day, the continental countries, their legal systems are still based on the Napoleonic codes. I don't have time to go into the details of how it functions, but you can go and read quite a lot in my submission to the House of Lords EU Committee last year, with a full version of what I submitted. It's called Serious Risks, and it is on, it's on the Freedom Association website, www.tfa.net/research, and it's the third item down on that page. Now, the European Court of Human Rights is the third item, it makes a lot of people angry in this country because it prevents our authorities from dealing with criminals in the way we see fit. But not only that, it fails to protect basic human right of freedom from arbitrary arrest and wrongful imprisonment, because when it doesn't even do what it says on the tin. Because when it was designed in 1950, they wanted all sorts of different countries, from Britain to Turkey, to sign up to it. So they had to make a very thin blanket. In fact, in the things that we are accustomed to, almost like the air we breathe, like trial by jury, habeas corpus, which means no arrest without evidence having already been gathered. On the continent, they do it the other way around. First you are arrested, and then they try to gather evidence against you. It doesn't mention any of these. Article 6 says that a prisoner shall have a right to a public hearing before an impartial tribunal in a reasonable time after his arrest. But they don't say what a reasonable time is. For Turkey, it's 6 months. In the Corpus Juris proposal, and I was present at its unveiling at a seminar in Spain in 1997, it is 6 months. The Corpus Juris proposal for a single European-wide criminal code for the whole of Europe, including the British Isles. And I was present at the seminar where this was unveiled in 1997, and they're still there, and it's going to be the handbook of the European Public Prosecutor who is being set up now. Well, one of the points the campaigning points was already touched on by Paul Oakley, which is the European Prosecutor. Although all three parties rejected the proposal, the Lib Lab Cons all rejected the proposal at the in a debate on in October, on October
we've just got our last speaker on. Do you want to just stay on the line?
They now want to reaffirm
and then
to reconfirm.
What we'll do is Herman is going to go on stage and talk with you.
What they don't realise,
you won't be able to see him. We can see you.
Is that
just be aware.
Under the Corpus Juris, which will be
it might sound a little bit disjointed, but that's what he's going to be doing. He'll be up at the podium, okay?
To order, to instruct a national judge under his jurisdiction.
Yes, mate, that's fine. Yeah.
To issue a European arrest warrant.
Okay, so if you just stay on, and the next voice you hear will be Herman.
Route, he will be able to arrest anybody in this country.
Thanks, mate.
The European prosecutor, not just national prosecutors, but the European prosecutor will be able to arrest people. And he can do it on any pretext, because they don't have to produce evidence. Some of the languages used in continental countries, I'm afraid, including Italy, where I've been living for a long time and I'm bilingual, don't have a real word corresponding to our concept of evidence. They have a word for clue and a word for proof, but they don't really have a word for evidence. So there are big difficulties there. So we must campaign to make sure that the government does not reconfirm the European arrest warrant. And they have no excuse, because the Treaty of Lisbon, under which the 130 opt-out and the 35 opt-ins are being conducted, allows Britain to make the opt-out and does not compel us to make any opt-ins. We can opt out of the European arrest warrant without having to breach the treaty, which, of course, the Lib Lab Cons don't want to do, but they want to reconfirm the European arrest warrant. And the other thing, the other campaigning issue I wanted to raise and to put to the party is the European Gendarmerie Force. I think we have a couple of slides on that. I don't know how to put them on the screen, but the European Gendarmerie Force is, yes, there we have, there are 6 participating nations, Italy, Romania, Spain, France, and a few others. We are not participating because we do not have this. These are police, by the way, on riot control duty. They are 2 nations and they're being welded together. They've got the Italian Carabinieri on the right, It's written on their shields, and on the left, I think it may be the French or the Dutch riot police. These are lethally armed, centrally recruited paramilitaries who are deployed all over the country, in each country where they are. Now, in June in 2012, Dominic Raab, MP, put a parliamentary question to the Home Office and said, would the Home Secretary be willing to call on special intervention units from our EU partners to come and give a hand if needed? Can she envisage any circumstances under which this could be requested? And the answer by Mr. James Brokenshire on behalf of Mrs. Theresa May in Parliament, and in my submission the exact parliamentary reference is mentioned, the answer was, of course we would, if we felt the need. Now again, what the poor dear, and I'm being very charitable, doesn't understand is that the European special intervention units are the Spanish Guardia Civil, we heard about them earlier, about the Italian Carabinieri, the French Gendarmerie, and so forth. They are, in effect, military. And once they are in our country, with their boots on our ground, with the consent of our government, they won't leave if asked by the government. Because they will say, we only take orders from Brussels. As we know, Brussels claims supremacy over Westminster. The EU have aspired to control over this country, and by then they will have it. So we must demand that Mrs. May disown that rash and reckless statement.
Hear, hear. Torquil, thank you. Torquil, I would ask you to stay there. I just wanted to say, Torquil, I'm afraid your time is up.
Oh, yes. I see the red light. Oh, yes, I'm sorry, I overran. Oh!
French. Take him away.
There we go. The Spanish Guardia Civil are practicing.
Thank you very much.